This podcast is for informational and educational purposes only and should not be construed as investment, tax, or legal advice. Any examples or frameworks discussed are general in nature and may not be suitable for all investors. All investing involves risk, including the possible loss of principal. Past experiences and planning approaches do not guarantee future results. A lot of estate planning is built around assets and decisions that you might call traditional. But in the last 20 years, with the rise of social media and our digital lives, things have vastly changed. And if you haven't looked at your estate plan for a while, you might be missing something really important here, which is your digital assets. Now, before I get into it, this is not legal advice. What I'm discussing here may not actually apply to you. The laws governing estate planning vary by your jurisdiction, and if you're considering updating your estate plan documents, you're going to want to consult your own legal counsel regarding your specific situation before you move forward. Now, you might have a tightly crafted estate plan, trust, will, healthcare directives, everything you would typically see. If you're not specifically addressing your digital assets, you might be creating a serious headache for your heirs. So if you died unexpectedly, what questions might your family be asking? Like, what accounts exist? Where are they stored? How do you even access them? They might not have passwords. Accounts might get locked. The devices you use for two-factor authentication might be inaccessible. It all comes down to a lack of access. And to be clear, when I'm talking about digital assets, I'm not talking about physical devices like laptops or phones, hard drives, that sort of thing. Those are personal property. From what I've seen, they're typically covered in existing well-crafted estate plans. But the real issue is what those devices access. So things like email accounts, cloud storage, social media, photo and video libraries, airline miles, loyalty programs, crypto wallet, even things like blogs, domains, online businesses. So if you're hearing all those things, some of those might be really meaningful in a bunch of different ways. And if you're thinking about those in the context of your business, it could have some serious financial and operational value that's at stake. And here's where things get a little more complicated. You may not actually own your digital assets in the traditional sense. So when you sign up for a variety of different things in the digital world, you're operating under their terms of service agreement and you're just adhering to what it is. You're probably even thinking to yourself right now, when I check that little box that says, yes, I agree, I haven't even read it. That's pretty typical. But in those agreements, there can be things like non-transferability clauses. So that's like, you just can't pass your account to someone else. They may even said like, you don't actually own what's here. You might be getting a lease on these digital assets. And they might even spell out restrictions on who can access the account, even after you die or just become incapacitated. So even if your estate plan says someone should have access, then the platform itself may indicate otherwise. And again, this becomes pretty critical for someone who owns a business. So like imagine this scenario, and this may describe you, but you own a business that relies heavily on digital platforms for like marketing or even distribution of products. And then the accounts that are managing those critical pieces, they might be tied to an individual's personal login. And there might not be a clear separation between personal and business for this scenario. So what happens if that person dies? If the account's in the individual's name, can the business even access it? Maintain operations? At this point, it's not even a question of inheritance. It's really about control and operational stability. So this is why it's important to seek out legal counsel, just to see if your business assets are properly structured. That way you can mitigate the risk that key personnel might die or even become incapacitated. So relatively recently, a lot of states, not all of them, they've adopted something called RUFADAA. It stands for the Revised Uniform Fiduciary Access to Digital Assets Act. What it does is it allows you to designate someone to access your digital assets, similar to how like an executor or trustee would operate, but you do have to explicitly grant that authority. Now, after I first learned this, I went into my own estate planning documents to see like, is this even in my personal documents and should I get it fixed? And it was. We updated in 2024, and it is clearly there in black ink that our digital assets are specifically authorized to be accessed by the trustee of the trust. Now, even within that provision, there's still like an order of operations that tends to happen. This might not be in all cases, depending on your jurisdiction. This is generally how you can view it. So first is on the platform itself. For instance, I've already indicated on my Google account and my Facebook and Instagram, anything to do with Meta, my wife can have access and under what circumstances that would take place. So because it's on the platform, it supersedes anything else because it's going off the platform's terms and conditions. Now, most other things don't have that explicitly worked into their platform. So then you look towards your estate planning documents. Beyond that, you can look at the terms of service agreement. And then beyond that, the catch-all would just be the applicable state law. And this isn't a guaranteed setup of what would happen. What you set up inside an account can clearly override what's in your estate plan. And what's written in the terms of service may override both. Something you have to discuss as a risk with your estate planning counsel. And if you haven't set this up already for Google, you can just set up a legacy contact through your inactive account manager, and you'll be able to set up access for whoever you want and have a trigger for how much inactivity must have elapsed to initiate that access. And you can also choose whether the account will just be deleted. And then for Facebook, it's similar. You have a feature you can set up in the memorialization settings, and you can also request that your account can be deleted altogether. So what I think makes a lot of sense here from a planning perspective is to focus on a few key principles. So have visibility with your loved ones so they understand what are the digital assets that you own or that you have access to. So having a clear written inventory is helpful. You want to maintain control of the access in a balanced way that doesn't put you with a greater amount of cybersecurity risk, but also gives someone else the opportunity to access it if they need to. You should also have legal alignment, which I've harped on enough already here. And then if you own a business, you should have some structural clarity on what's strictly personal versus what's business, and then set it up that way so that there's proper access based on the actual operational needs of each digital asset. So again, if something happened tomorrow, would your family know what exists, where it is, and how to access it? My guess is that most people can figure out what exists, but fewer are going to know exactly where it is, and then even fewer are going to know how to access it. So setting up that framework while you still can is very important. So to sum it up, the big takeaway here is that the world is changing, and with AI, it's changing even faster. Your estate plan should reflect that, and that you're not just transferring ownership in this scenario, but you're ensuring the continuity of access, control, decision-making. And as everything gets more digital, I really got to say that access kind of becomes everything.